We are live. We're coming to you live from House Transportation on Wednesday, April 23rd, picking back up on S-123 miscellaneous DMV bill, trying to figure out which sections we need to hear more about and which sections might be completely technical in nature that we can check off and make sure we understand the money side and the policy decisions and whether we need more witnesses and where we're at. So I think we're ready to start section 19 unless there was more to go. We know we have to talk about section 18 some more, is what I gathered out of that. At least we as a committee need to talk about it more. It doesn't mean that we need additional testimony or not, but we're definitely talking about it more. But not right now. We'll put that on the agenda to talk about with all the other pieces. I think we can pick up with 19 and keep moving through which ones we can check off and which ones need follow-up. Otherwise, Damien, I sort of will throw it to you. We're back and forth.
Yep.
Number 19 from the DMV.
Yeah, so number 19 is commercial driving instructors, and the language was added to bring us into line with I believe with the federal standards for commercial motor vehicle instructors. There's two different types. There's behind the wheel and theory instructors. The standards are extremely similar for them, but we're essentially mirroring language here. So I believe, DMV asked for this, so, and I do not recall any testimony in the Senate in opposition to this or that raised questions.
And we did hear from their commercial driving, their enforcement guy who also does the training and trains the trainers and does some of the training classes. We heard about from him last week. So he talked quite a bit about going to the experience versus the number of hours. It was far more about, remember you talking about farm kids that have been driving forever and then you get their commercial driver's license. That's a whole different level than somebody that's starting out brand new. So, yes.
So is this to get in line with the federal government? Is it to, give a little leeway for the DMV? Or is it a combination of both?
My understanding on this section is that this is matching up to federal language on the requirements, on the experience requirements for these driving instructors. On the next section, motorcycle instructors, giving leeway because we don't have enough right now.
As far as you know, it's fair to say this section here is just to align with the federal standards.
Right.
As far as requirements.
Right. That's my understanding. Is it's just bringing us in alignment with updates.
The next section was about the response if they just don't have enough instructors and they would like to loosen the requirements.
Yes.
But I understand where you were headed with that because that might have been an issue with the truck driving instructors too.
Yeah, sure.
Yeah, this is, what you see here is we're not actually replacing any language. We're adding new language on the requirements that they have to satisfy for experience. That's a contrast to the motorcycle instructors where we are clearly changing years of experience.
Does it make it tougher for somebody to be an instructor, or does it take the instructors already that we got and makes it so they're not qualified, any of them, or is it?
I don't know the answer to that. I imagine, so the requirements here are, so let's take behind the wheel instructor. There's two ways to qualify. First way is that you have to hold a CDL of the same or higher class, which is standard for an instructor, with any endorsements necessary. Again, standard. You have to be able to operate the vehicle you're teaching people on. And then you have to have at least 2 years of experience driving a commercial motor vehicle of the same or higher class that requires any of the same endorsements. So pretty straightforward. It's basically a 2-year experience, licensed experience requirement. I don't know that that's going to
Is it any different from before?
So the prior requirement said that you had to, in order to qualify for the license in general for an instructor's license, there's a requirement that you not have been convicted of a felony within 10 years and certain other offenses within different time periods. Then you have to pass an examination. You have to be physically able to operate the motor vehicle and to train others. And then you have to have 5 years experience as a licensed operator,
Okay, so it's eased it.
but not necessarily, and that language is staying on. It's not necessarily for the same class. So that, in other words, you have to have 5 years experience as a licensed CDL operator
In order to become an instructor.
in order to become an instructor. That doesn't mean, as I read this, you only have to have had 2 years though at the class you're going to be teaching on. So if you've got a CDL and then you got endorsements to operate a higher class of vehicle, as long as you've got 2 years with those endorsements, you'll qualify as behind the wheel instructor for that. But you have to have been operating a CDL for 5 years as a licensed operator. And we're not taking that away. So really, it's adding specificity around the type of experience. And then their alternative qualification is, again, same or higher CDL license and endorsements. And then at least 2 years experience as a behind the wheel instructor. And so that basically means that if you've been an instructor and you've just gotten endorsed to operate this other vehicle, that 2 years experience as an instructor can replace the 2 years experience driving the new vehicle that you just got the endorsement for, if that makes sense. So it's basically providing two paths. Under all of it, there's no change from the prior requirement that you have to have 5 years experience as a licensed CDL operator to even apply for the license. And then to get approved for the license, you follow these tracks. And so it's just requiring, I think, recognizing that there's a wide variety of CDLs and a wide variety of factors that come into it that you have to have that experience.
I was just hoping that we weren't creating a shortage of instructors through changing a few things. That's all. That's all I was kind of getting at.
I don't see that from the language, but I need to emphasize too that I am not a CDL driver.
Yeah.
And I don't know the ins and outs of the program. So that would be a better question for the department, just to make sure that they've got that. Yeah.
Two comments. One, on the CDL instructors. So perhaps my notes are incorrect from April 15th, but I thought when we had testimony from Pat McManaman, who's the education unit supervisor, Pat testified that right now CDL instructors have no prior driving requirements, unlike driver's license instructor requirements. And so this change was bringing our CDL instructor requirements in line with our normal pleasure vehicle drivers, driver instructors.
I would have to look at the statute for the normal pleasure vehicle instructors. So I can't answer that off the top of my head.
Okay.
With respect to this, I can show you the existing statute and we're just adding to it. And I think, and I don't want to speak for Pat, but I think what he was getting at is we didn't have that sort of specificity, even though we had the requirement for licensing. But maybe I'm reading the law differently that it's been implemented. But this is my understanding from looking at the law. And again, apologies, but I don't have deep familiarity with the CDL program, being new to this role. But here, if share my.
Pat McMahon did testify and talked about this piece. And I couldn't tell you that I remember every detail of it, but he did talk about why the changes. He had come in that one day, then he came back later on. So I guess the question really comes to, do we want to hear from him again? Because we're not gonna be able to solve each one of these today. We definitely want to get through whether we need to hear more or not.
So I'd love to clarify
So
what the actual change is and what the current statute is.
And the reason for change.
Yeah. And my other question is regarding the motorcycle instructor licensing going from 5 years of required driving experience to 2. I also recall in, I don't know if it was that testimony, but it was other testimony last week about a number of different motorcycle training programs at a number of different facilities, and comments that that the Department of Motor Vehicles had to cancel several training classes for low attendance, which suggests that maybe they're giving too many and they have too many. So you're just thinking about affordability and like, do we really need more instructors, or maybe we just need less classes? I'm just bringing that up.
Representative Hughes?
So there's a difference between having those classes not be full, I would think, and the instructor that has it. For CDL instructors, my experience is there's a private enterprise that does that.
That's right.
And then it's the state then regulates those instructors to do it. And then the person that then is in DMV to assess the qualifications of a candidate is something different.
Right. And I just, as we were talking about this, I realized that I was misreading section 705. And it actually makes sense now with Pat's testimony. And I apologize for that. So as I was reading it, my brain was thinking we were in the CDL section. So we were, of course, referring, anytime we said instructor, we were referring to a CDL instructor. We are in the general motor vehicle law here on instructors. So when we're talking about instructor, this is all instructors who get licensed to teach driving of any type of motor vehicle have to have 5 years licensed experience, which could be a non-CDL. So Pat was correct when he said this is adding for commercial driver's license instructors a CDL experience requirement. So it is making it harder.
Yeah.
And I apologize for the wrong testimony. It's been clearly I need to sharpen up on these things here, but we'll get there. I promise you guys 4 or 5 years, I'll start to understand. We'll be okay.
We'll be there with you.
I've been using that saying all session.
Yeah, we'll just keep doing this. I'll turn red a little bit, and then we'll move on. But yeah, this is the generalized instructor language. So right now you can get an instructor's license, and it doesn't require that any CDL experience. And this is specifying CDL license and CDL experience for CDL instructors. And so that is bringing us up to that point. So it's ensuring that whoever's actually teaching you has actually driven these vehicles with a license before for at least 2 years. Okay. So maybe you don't need Pat to come back in.
That solves my
Okay.
question. Yeah, so thank you for
Well,
clarifying
this is
that.
why it's good to ask the questions, because these are the moments when you realize that you had it backwards. So, but yeah, you going to section 20, which is the motorcycle instructors, and this is specifically this is under the motorcycle rider training program subchapter. So we are definitely talking about motorcycles here. And this is providing minimum requirements for the rider training instructors. And we require by statute those requirements to include certain things, and then the commissioner has discretion to add other requirements. But we're changing the current requirement here of 4 years of licensed experience as a motorcycle operator to 2 years of licensed experience as a motorcycle operator during the last 4 years instead of the last 5 years. I would note too that the prior language did not actually require licensed riding experience, just riding experience. And I think that was just, just some casual drafting there when they enacted that. This does lower the requirements, and it does. I don't know the answer to Representative White's question about, if we have classes being canceled because there aren't enough folks attending, is this necessary, or could there be another way to address the situation?
Representative Cox?
So is there a difference between an instructor and a license? So you have to have a license. So you need to be have a license to drive a motorcycle for at least 2 years.
Yep.
Okay.
Yeah. So you have to have
So
been.
as an instructor, you need 2 years riding on a motorcycle.
That's right.
Is that enough? I don't know. I've never been on a motorcycle. So I don't.
It was 4 years and
But is it the only reason why we're lowering it is because we don't have enough instructors? Because that doesn't make me feel all warm and comfy inside.
that was the request of the DMV. That was the testimony that the head of the enforcement or head of their training, Pat McMahon, testified on the motorcycle piece that he has people that he was looking to make instructor, but the law says 4, and they would like to see it reduced to 2 to make it available. They testified they didn't have the level of classes that they had pre-COVID. They would like to. Was part of what he had said, but that doesn't mean we couldn't hear from him again or not. Yes, Representative Casey, I think, or Representative Coy still got it.
So technically, somebody could pass their motorcycle exam, maybe ride twice in the 2 years that they have been licensed and become an instructor.
Not without going through their class and their program to be an instructor that Pat runs.
So
They
they
can't even get into the class to become an instructor without having been a licensed driver for 4 years.
Yeah. So there's a.
You don't become an instructor automatically.
rigorous
You have to go through the,
training for it. Okay.
Yeah, you have to successfully complete the department's course for instructors. Part of that is showing not only knowledge of like the book learning materials and the safe motorcycle operation practices, but also showing that you're a proficient rider.
Okay.
So,
All right.
Well, that was kind of, that's kind of like what my question was, is like, is it 2 years like practical experience, like 2 years of time on the,
it's 2
or is it
calendar
2
years.
of license, holding on to a license?
It's 2 years of holding onto a license. There is a demonstration of riding proficiency that's required by statute for the instructor preparation course. In practicality, I don't know what that looks like. And I don't know how easy it would be to meet that. But I do imagine that, just like was mentioned with, kids who grew up on a farm and then get their CDL at 18 are way ahead of someone, who grew up driving the family hatchback and then has to learn how to drive a CDL. And here, I imagine that you're going to have folks who get their motorcycle license after years of riding dirt bikes or motocross or, four-wheelers are going to be ahead of folks who have not done that in the past. So it's probably pretty hard to say hard and fast, 2 years for person A is going to be the same as 2 years for person B.
Right.
And 2 years of daily riding is going to be different than 2 years of riding once a month.
4 years probably to get actual 2 years of, because you're only riding for half a season, for half a year.
Right, unless you're a snowbird.
Right.
But if you have questions about the proficiency demonstration, I think that's a better question for DMV. To kind of come in and talk about what they require to actually complete the course, and whether that makes sense with the change in the requirements here.
we I guess my thought to that is we had McMahon being here for quite a long time, and he went through all of the motorcycle requirements. He went and showed us where they give the test, how it goes through all of the piece.
Yeah, he did.
Talked about the instructors. He went through also. We can have him a reminder or a piece if we want, or we go back and look at his testimony they didn't provide. If you want him back, I guess at this point, as far as being able to move on, we want clarification back in, or are we good with what we've already done?
I got my clarification. I was good. Patty was kind of asking the same question I was. I don't think we need to bring him in, but
Bring him back. Yeah, he's been here twice already, but
Fine.
I'm fine with it.
do we know the Senate? Did they have anybody testify in this outside of DMV or not?
They,
Truck and bus or anything or not?
I think it was just DMV.
All right, that's good enough.
Um,
All right. So I need to say, move on.
Making my life easy here. I appreciate it. So,
Section 21 truly was about the fact that the JD Powers was
yes.
bought out and that it's true. It's just completely a clerical. Everybody's
Yeah, so JD Powers acquired NADA and rebranded the used car guide. And that is it in here. All the other changes are just the same changes I've been making throughout, where instead of using sort of the vague him or her, he or she, I'm just naming who the person is to be consistent with our new sort of standard drafting format.
okay. So section 22, the first bullet point would be the same thing, but the second bullet point is likely actually something else.
Yes.
So the first bullet point would be a sort of a check mark clerical, but the second bullet point is a new process, and I thought that was part of what or it was a documenting of a current process that they already is in, according to DMV Deputy Commissioner that was here today. He said that section is a documentation of their current practice. But there was also section 22, the second bullet point, or well, I'm looking at the summary page. So we're in section
Near the
22.
end, 22.
Right, in section 22.
Says the commissioner may develop a process to determine the value of vehicles that do not have a clean trade-in value and JD Power values.
And that's for over 20 years old then, is what that's all about, right?
Right. And I think part of this too, by adding in the language, you're clarifying that the authority exists for the commissioner to not only have developed the process that's currently there, but to revise it and refine it. And that to some extent dovetails with the study language at the end of this, if they determine, although that's purchase and use tax, but this is all purchase and use tax, I'm sorry. So it dovetails with that if they develop a new process for taking older model cars and adjusting the purchase and use values, that could lead to a revision of this process or additional appeal options or revised appeal options, assuming you move forward with that language, which I know the department is, I believe, opposed to.
I also know that in this particular case, anything revolving around the value of used cars, the Lieutenant Governor wants to testify, so we're not checking this off. He's got an affordability issue in return to when you buy the cars that we've heard about, what the value is. To me, that section sort of speaks to that, and I've already got a note on here, so we're going to hear from him. So you can check. The first part of 22 is good, but the second part is we're going to hear more testimony on that. So that moves us to section 23.
Section 23 is also purchase and use tax. This is setting a timeline for when you can apply for a tax refund if you've overpaid on the amount of the tax. So currently the statute just says any overpayment shall be refunded. And there's no timeline. So theoretically you could come in at any time and ask for a refund. This is saying that to be eligible to receive that, you must submit the request within 1 year after you paid the tax. So that sets a pretty firm deadline there.
Representative Pouch?
maybe we heard this, what's an incident where you would pay the tax and then what? Come to realization you wrote the check for too much money or it was unfair or?
So let me take a look at the statute here and see, because I think there are some timing issues in the statute where if the value is adjusted, but you've already paid.
Okay, you might pay just to get it registered and then you're fighting it maybe, yeah.
Yeah.
About when you, like if you buy a new car, right, and it's part of it too, and you sell your car that you currently drive, like you didn't
Yeah.
trade it in, you decide to try to go for more money and is that part of that too?
That
Got a year?
I believe that all ties in. Let me just find the right sections here because there's a couple of different things at play.
Thought that was part of it.
Yeah, so if we look in it here, the tax is imposed on the taxable cost of the motor vehicle at 6%, or $2,486, whichever is smaller. And then hold on. So I apologize here. There's a lot of language in here to skim through to find the right piece.
Okay.
So there we go, computation of taxable. So if we look at this, there are different values based on lease end value and so forth. There are exceptions provided to the tax imposed by the chapter for example, if it's owned or leased by a religious or charitable institution or volunteer fire. So there theoretically you could unknowingly pay the tax and then realize you're subject to an exemption and then request a refund after you demonstrate the entitlement to the exemption. There are let's just see here. There are a number of these little carve outs here throughout the chapter. And I'm trying to find the one that you just mentioned because I believe that there we go, in 8902, 4 and 5. Purchase price of a vehicle means the gross consideration that you pay, so the money you pay for it, plus the value of any services or properties given in exchange for the motor vehicle. And then taxable cost means that amount excluding the value of any motor vehicle that was traded in, or the amount received from the sale of a motor vehicle that was last titled in your name that you then sold separately. So as long as that occurs within 3 months after, so there's a chance that you take your car, you sell it on the open market 60 days later, and it reduces the taxable value of your car too. So you've got really, I see 3 options. One, it's overassessed and you argue the assessment, but you've paid in good faith. 2, you're subject to an exemption and you don't realize it, and then you claim the exemption later. And then 3, you sell instead of trading in. As long as you do that within 90 days, there's a reduction. So those are the 3 I'm aware of. Apologize for the time it took to get through that. One of these days, I'm just going to have these answers for you.
Who who would testify to whether the year is a reasonable amount of time frame? As far as the law part goes, regardless of what your opinion of it is, we're putting a restriction in that says you got 1 year to apply now. Right now, it's unlimited, which I understand that if you have a hard time, just have things that go out there forever. I get the request to put a limit on it. But how do we know whether a year is reasonable? Who would speak on the behalf of this being reasonable or not reasonable? Somebody involved in dealership, somebody involved in sales, somebody who would be eligible to these exemptions. Who's the other side except us representing Vermonters, putting a restriction on Vermonters?
States attorney, what's your name? The attorney, not attorney general, it's just federal
Secretary of State?
secretary. No, yeah.
Secretary of State or AG?
Yeah, attorney general.
Yeah, Charity Clark.
Yeah, Charity Clark, that's the word. Charity, I don't think Charity. She would have a broad perspective, maybe.
Yeah, and I'm wondering, you may also just want to reach out to various consumer advocacy groups. AARP potentially may have have thoughts on it, just folks who see if they have any comment. And you may just ask your colleagues down the hall in Ways and Means if they have any taxpayer advocacy groups that comment on these issues for things like property and income tax.
I was probably presumptuous. Does anybody else have an opinion on that here? I guess it's we have to hear from some other side, essentially for limiting a Vermonters opportunity. Does anybody unless it's somebody
It
else?
seems like a year is a reasonable amount, but who knows?
We don't
It
know.
was 3 months on,
So
3 months on selling your vehicle, right?
right, so that would give you 9 months
Should be heard.
left after, assuming you pay the tax the day you buy the new vehicle, then you sell within 90 days, you have at least 9 months from the date you sell to claim the refund. But yeah,
Okay. So we'll follow up on those particular pieces and see who else might have an opinion. We'll send back if somebody has an opinion. Section 24,
24.
straight other cancellation. So
Yeah, this is a,
when you were talking about the article of their car burned down, it was in there.
yeah, I mean, that's exactly what this
Giving the
is dealing
commissioner a
with.
little more leeway to accept other reasons so they can process.
If your plate's melted and
Replace it.
your registration certificate burned up in a car fire, it will allow you to still get a partial refund of your registration.
This is giving more leeway to the commissioner to give more leeway to Vermonters.
Yes.
Do we need to hear anything more about that? We're making it less restrictive? Is there anything, unless somebody has a problem with that idea? Is there any reason we'd have to hear the other side if it's less restrictive?
Yeah, no, it is. I mean, what the registration certificate, how would that burn out? Or lose it? I mean, isn't that like digital?
Now, right? Yeah, so I guess.
No, I'm just wondering why we would need other proof. You're always gonna have that.
I think the way it's worded, I think their concern is that the registration certificate has historically been that piece of paper they send you with the plates and then and that you get updated periodically. And I think that they want to allow for potentially the digital copy or other proof if there is some issue with getting that for whatever reason.
All right, yeah, that's one.
So, yeah, the or other proof, we came up with that language to provide discretion. So I like to call that future proofing the language. So,
Check that one, okay. 25.
these are the fuel tax credits or tax refunds that we talked about earlier,
33 to 12 months.
right?
Yeah, well, we'll have to hear, there's no doubt, we'll have to hear, so we'll start with the fuel dealers and go from there.
Yeah, and you may want to hear from, for example, like VLCT or someone like that who may be seeking these refunds.
Okay,
I believe that's what the department testified to, is that municipalities.
wholesale dealers and municipalities and, okay. Whoever else is entitled to these refunds. Number 26.
All right. 26 is, this is the alteration of odometers language. This was also a DMV proposal. Part of this was really trying to make the language clear. It was, if you look at the language that was crossed out, it was repetitive and ended up getting a little bit confusing. So part of the, I think actually most of the work that I did here, if not all of it, was just to clarify the language. And then the final piece here on subsection B at the very end, one of the problems that came up, and I'm remembering my conversation with DMV's counsel right now, is that the question was, does the fine apply to the entire list of alteration of odometer offenses or just the last one in the list? Because the way it was written as a run-on paragraph, essentially. And so what we did is broke it out into the 3 separate offenses, reworded them so it was more clear what is actually an offense, and then clarified that the penalty applies to any one of the 3 offenses, which would be our understanding of what the legislative intent was likely when this was attached or adopted.
When you testified on this section before, I had written technical changes, not substantive,
Yeah.
trying to be more clear.
Yes. That's how I would interpret
Not an
this.
intent change, not a policy change,
It's
trying to make the language
Yeah.
more clear and with the DMV attorney and yourself.
right.
Okay. Do we need to then in that situation, need to hear any more or not anymore? Unless somebody's a lawyer that wants to argue with the other 2 lawyers?
There's a highway building plans, those crossed out.
Yeah.
I've heard of that term. What are we crossing out there?
Where are you crossing?
So-
You're leaving it in right above.
Right,
We have different pages of this.
page 34.
So
Page are you on?
34.
Yeah.
So what we're crossing out is the old language was
You don't have all-
change, tamper with, or deface any odometer, hubometer, or clock meter in a motor vehicle, highway building appliance, motorboat, all-terrain vehicle, or snowmobile,
Happy.
which under normal circumstances and without being changed, tampered with, or defaced.
Okay,
Yeah.
Six 34.
No, we were just trying to figure out the drafts there.
I was on a draft,
No,
not
Matt,
final
yeah,
version.
he doesn't have a.
But those are where my notes are. When you did your walkthrough, we were working off the last draft.
Yeah.
That's where my notes are.
Page are you?
34. Top 34.
So
So sorry about.
the short answer on highway building appliance
Yeah.
is that I deleted it because they simply repeated the list of motor vehicles twice. I can tell you what I assume a highway building appliance is,
Yeah.
but not being 100% sure, I didn't change that term and just left it.
I didn't notice
It's
that
where-
those.
yeah.
It's where they mix the brine.
Yeah.
It's that brine mixer we saw.
Yeah.
But yeah, so
Or is
that,
that when you drop shit off?
that's a,
You drop the washer and dryer on the side of the highway because.
You think that's what the-
all right.
So this is just,
It's just deleting repetitive language. In that case, so, yeah, and I mean, that subsection 2 there, the other piece was, any gauge, dial, or mechanical instrument commonly known as an odometer, hubometer, or clock meter. Why don't we just call it an odometer, hubometer, or clock meter? Because a lot of this language is, it's really old. And so we're going back to something that was drafted to seem really, to address what may have at the time been relatively new technology and done in a way that was very legalistic and not very user-friendly. As I like to say, why use one word when you could use 50 is the drafting approach we see here. And so we're just kind of taking that down because the previous section, it took me 3 or 4 times reading through it to actually figure out what was prohibited. So this is a technical change just to get rid of repetition. Although if anyone wants to change the term highway building appliance to something that's more current.
Is that like a paving machine? I mean.
Yeah, I have no clue.
Yeah, I looked it up. It's
Is it?
like construction equipment for highways.
All right. Why you'd say
We'll just leave it
What do
alone.
you call it,
unless they
appliance?
Wildlife. We'll just leave those.
Yeah,
I mean, you'd think they'd use equipment.
Yeah, equipment.
you would think so.
And I think they also said they wanted to capture the new technology, the digital, it's all digital, there's no clock thing anymore, so.
Yeah, this is, yeah, this is one of those examples of, let's just be glad that language has moved on.
Okay,
So,
that makes 26 a check.
all right,
All right, 27,
27,
28, 29, all,
Technical.
and 30 all looped together.
yeah, they are all adding a cross-reference to our existing definition of conviction because there has been confusion over whether the definition of conviction, which is in a definition that section that says this applies to the entire title, actually applies to those sections. So because people couldn't understand this applies to the entire title, we've added it to these 4 sections to drive home that yes, we really do mean conviction like we defined it. So that is all this is. DMV noted that they had difficulty in some proceedings around dispute over what a conviction meant for purposes of their statutes. So they wanted clarity in there to stop having that question and the need to go back.
Do I need to have some other advocate group of DMV rule violators to come in and tell me why we shouldn't make this change?
So
Is there another side of this opinion other than clarification from the DMV's?
you're not changing existing law. You're simply putting in a second reference to what the existing law is. So,
Does anybody else think that we need to hear from anywhere else? Is there a second?
So I just have a question. What is the meaning as it appears in section 460 of this type?
sure. So, go back to that section. It is defined currently as
Division 4. 60. Lot of numbers.
yes. Oh, we have over 80 in that section for the entire title. So conviction is an unvacated final adjudication of guilt, a final determination that a person has violated or failed to comply with the law in a court of original jurisdiction or an authorized administrative tribunal, an unvacated forfeiture of bail or collateral deposited to secure the person's appearance in court, the payment of a fine or court cost, or a violation of a condition of release without bail, regardless of whether or not the penalty is rebated, suspended, or probated. Conviction shall also mean a plea of guilty or no contest that has been accepted by the court.
That seems pretty clear to me.
What is that?
Yes. So yeah, it is clear and thorough. I forget what the exact dispute was that was described to me, but it was something in that list was something that had come up as a question in outside proceedings
Okay.
that related to a motor vehicle conviction. And they wanted to make it crystal clear that
They have.
when they say conviction,
Okay. Agree
so
with that.
yeah,
Okay.
okay.
So are we treating 27, 28, 29, and 30 all as the same update and we're all good with a check on that? We don't need to hear any more already. That means we're into 31.
31. So
Driving.
drunk driving.
Here we go.
Yeah, so the issue here is that
At or above?
it's the at or above clarification. because,
Because it was just above, now we gotta go at or above.
yeah,
The .08s used to get away from it, and now they can't get away with it anymore.
well, I think it's been enforced as 0.08 or above. But the language doesn't agree with that throughout the chapter. And so what we've done here is clarify that, yes, it is 0.08 or above.
And that's the language in the rest of the statutes all over the place, referring to anything to do with is or above, or that's what we're trying to do.
Yeah, that's what I thought. We heard testimony. That's what, in other places in judiciary or something, it's
Yeah,
0.08 and above.
my understanding is that we're bringing it into line with the other statutes. Of course, being worried about misspeaking, I'm double checking. But yeah, so for example, we under the when we say the actual prohibition as a person shall not operate any vehicle when the person's alcohol concentration is 0.08 or more. And so that's where we get to the at or above. So the actual prohibition is the level or more, but the language itself elsewhere in the statute just said above the legal limit. So we've been enforcing as at or above, but the statute did not reflect that throughout. So this is 23 VSA 1201, which I can flash up on the screen for everyone here. Is the actual standards. So you'll see that the general is 0.08 and it's lower if you are operating a bus or a commercial vehicle. So there we go from that point. All right.
Yeah.
If you're way over the limit, you don't have to worry about that little marginal deal, do you?
No, I mean, the people who would be affected by this are very, very close
Yeah.
to that limit anyway.
You're gonna do it right.
All those sections.
Yeah.
Stumble on the sobriety test, do it all.
If you want to.
Yeah.
We're at 32 now.
Yeah.
Yep. 32 is a little bit different. It's closing a loophole that was in the statute where so you can get a notice of intent to revoke the license or intent to suspend. However, if you didn't have a license to begin with, currently that notice says this shall serve as your license until your hearing. And so is creating a loophole where someone who was not actually licensed to operate a vehicle, but had been operating while under the influence, was now getting a temporary license on that sheet of paper. And since they don't take away the license card anymore, which is why they used to give you that sheet, the reason it no longer exists. So you're operating without a license. They wouldn't have taken away your license card anyway. So they're updating the form and closing up that potential loophole.
A loophole of giving out licenses to people that didn't have licenses.
That's for your second offense. Your first offense, the license is not suspended
Yep.
until you have a hearing, or if you do not request a hearing, your license will be automatically suspended.
Right. So this is really just the language in the notice of intent to suspend.
Okay.
So yeah, when they give that out to you, this is describing the information the notice has to have. And previously the paragraph there that describes the first and second offense requirements. Here, I'll pull it up on the screen again so everyone can see. And if it's okay with everyone, I'll keep this up on the screen, although I am taking notes. But currently, this is a paragraph of information that's required. It says the notice shall serve, this notice shall serve as a temporary operator's license and is valid until 12:01 a.m. of the date of suspension. If this is your first violation and you do not request a hearing, your license will be suspended. If this is your second or subsequent violation, your license will be suspended on the 11th day after you receive this notice. It is a crime to drive while your license is suspended unless you haven't been issued an ignition interlock restricted license. So this is the issue with this was that they were running into instances or had run into at least one instance where an individual who already had a suspended license or didn't have a license was operating a vehicle while intoxicated and then got this notice and said, well, I've got a license until 12:01 on the day of suspension. So it was a kind of bizarre loophole that we created there. And this is just closing that because they no longer take away the actual license card. So, or at least not at the roadside stop. So I think the courts testified down in the Senate that they were okay with making this change. I don't know if you've had them in yet. You could have them in if you want to ask about the process. But that's what this is doing.
Okay. 33.
Okay, so that's okay.
Well, we're gonna hear, I have to run all the judiciary bylaw,
Okay.
chair of judiciary, so we'll see what they have to say. Does anybody, unless somebody wants to specifically say they want to hear from the court?
So
This is out of our jurisdiction anyway, really, and it's split in the middle between them and us.
33,
Because that, you might know. Okay.
33 is it's adding an additional fee related to bulk electronic records requests. My understanding is that this fee reflects what they're already charging, but they're putting it in the statute.
They're certainly already responding to public records requests.
Right, they have to respond, they can pass on the fees. And this works out to, so the fee is derived, and not having done these records requests, bear with me, but I believe it's called a green sheet, and it's the number of bulk records that you can fit on there. And then they divided the cost for each of those sheets by the number of records to get this 30.3 cents per record fee that goes into it. So
There was some discussion about this earlier. Does anybody feel like they need to hear from anywhere else? And also with the data privacy pieces, should I throw it by Sharon James, just so she's aware it's there?
Has to go to Ways and Means.
The bill will because of the fees that are mentioned.
Should we asterisk this part or no?
Yeah, we can see what standards, and I don't know, did anybody testify on this, like the ACLU, like we're limiting people's access to public records because of monetary reasons? I'm not saying it's right or wrong.
yeah,
Sometimes that's where you get the pushback.
I am not aware of any such testimony.
Yeah.
The ACLU did testify on another provision of this bill. I don't know if they were aware of this provision when they testified on that other provision.
Yeah.
So,
I have to know what the other division was.
or it was, I'm sorry, on another proposal for this bill, which is not actually, which I don't think is in here. It came over as a separate bill.
Well, then forget that I asked.
Yep. So there you go.
I know I'm agreeing with what you're saying. I'm just saying if it's
Yeah.
more than one item, I don't know whether I should
So it was,
heads up because it's a thing and then.
yeah,
All right, well, then I won't check it off. I will do some additional research on that. But as a committee, we're not looking for anything particularly more.
right. It was requested to be added to this bill, but it's sent over as S66.
Other committee jurisdictions with the respect for their areas. That's what we'll do.
That's pretty funny. How do you collect that? That's out of the contents of the sin.
I have to imagine, and this is a good question for the agency, how they do that, since we don't even have half pennies anymore. I think we should bring them back personally. Yes, hay pennies. But I gotta imagine you round that one down. What are you gonna say? Get out the tin snips and cut the penny.
34.
It makes sense to round, you
No
know.
money impact on this, I'm sorry, Logan, on section 34, bulk electronic records request, 0.30 a record. There's no real financial, your only financial impacts are already, there's only like a couple of them, huh?
Yeah,
It's all.
Logan North, the joint fiscal office, this is not new, this is what is currently being charged, this is broken down to make it easier to understand how much you're actually paying per record. Normally it's charged per sheet. And then there's just the charge per record, and there's a certain amount that penalty fee, but it's not a new fee being charged.
Oh, it isn't, all right, that's scratch ACLU. It's already existing.
It's not new. Okay, well, that's good. All right.
Done with that.
That's care of that.
All right. Section 34, this looks like we're making big changes. We are actually not. So when I walked you through this bill, I took you down to this language in subdivision 2 that says fractions of 1,000 pounds shall be computed at the next highest 1,000 pounds, excepting, however, fractions of hundredweight shall be disregarded. So the way that was interpreted was that the first 100 pounds over the 1,000 was included in the 1,000. So the whole schedule is this 70,100 to 80,099, 80,100 to 90,099. So we are, instead of having that language in here and having folks say, but the statute says 70,000 pounds, and you're telling me the next 65 pounds are included in that charge. They just said, let's reflect the actual schedule. And so that's what we're doing. Doesn't change income for the state or fees that are being paid by anyone registering a truck at this time.
It's pretty obvious on page 45 what the changes are when they're all stacked up there.
Yeah.
That makes it easier. Okay, anybody have any issues? 35.
All right, back to purchase and use tax.
Want more?
We are adding a cross-reference to the definition of mail. And then just cleaning up some language in the cross-reference to the definition of motor vehicle for purposes of that tax in 35. So I don't think that this is really a substantive change. Theoretically, the mail definition is a new definition, but it's what's been applied, and they're just clarifying that they're using the definition that's in the motor vehicle statutes, which you added last year, by the way.
Anybody have questions, comments, thoughts?
So we had the defined male last year. Maybe it's the younger crowd coming in. They're like, what?
What's the mail?
Yeah. Well, when you look at how you defined it, yeah, it's the definition of it is nothing crazy, but I think it's broader than just the letter that you get in your mailbox, if I remember right.
What do we have to define for last year?
Digital stuff.
Yeah, so mail is any method of delivery authorized by the commissioner, which may include by hand, US mail, and or should say, well, I guess, yeah, and is fine, which may include by hand, US mail, and electronic transmission. So text message, theoretically, just saying. But that's your definition of mail, and this is just cross-referencing it.
Remember what we needed to define that for last year? Or no?
I don't remember. I imagine it was flexibility around the adoption of the new system, which is going to allow you to start emailing out notices.
Okay.
Okay, do we need to hear anything more on that? Okay. So 35 is getting a check mark. All right, 36. More clarification language staff. Maybe not. That's what I wrote down on this one part. 36
Sure. So 36
is clerical.
yeah, mostly clerical changes. The big change here is G and H. So we talked about this morning. This is language that codifies the commissioner's requirement that the commissioner establish procedures to file an appeal from the purchase and use tax liability. The department, my understanding is they already have these procedures in place. This codifies that requirement. And then it also requires the commissioner to create educational and outreach materials for taxpayers that provide information regarding the appeal process and opportunities to resolve disputes. The
Sorry, keep going.
two important pieces just to note here are the references to resolving the disputes prior to the issuance of the final administrative decision on appeal, and then the second reference to resolving disputes. The department wanted to have language that specifically allowed them to basically settle the appeals before they went through the whole process of ruling on the appeal. So if they're close, figuring out a way to find a number that works for both parties and then settle on that for the tax rather than spending the time, which may cost more than the actual amount of the tax, to resolve the appeal.
The appeal of the amount that they're paying. So this falls into the whole area that the lieutenant governor wants to be heard on, isn't it? About values and amount of taxes they're paying?
It's peripherally related to that, yeah. So I was not present for the lieutenant governor's testimony downstairs, but my understanding is that part of it is going to relate to appealing the purchase and use tax that's assessed. So this might not be directly on point, but it's certainly part of that whole process that I think he's going to be talking about.
Okay, well, we know we're gonna hear more about it then, so we're not checking that section at this point. Doesn't mean we won't soon, but not right now. So that puts us to 37.
Okay. 37, this is really a technical change. So you get 8 points assessed when you are driving 30 miles an hour or more over the speed limit. And again, this was the new in-house counsel or general counsel at DMV. In reviewing the statute, she realized that one of the 3 statutes relating to speeding violations, 30 miles an hour over the speed limit, wasn't cross-referenced. We're adding the cross-reference.
That seems pretty clerical. 8 points, how many do you get before you lose your license?
10.
And I guess this would be a doozy, huh? Okay.
Big one.
Ryan Smith would love it. The safety zone.
Yes. So we don't need anything additional on 37 then? Then we get into
Tinted windows, which you already decided you want additional testimony on.
38, 39, 40, and 41.
Yes.
All right, so
And then that gets us to whether ATVs can be 6 inches wider than they are currently defined, which is 42. Or 8 inches wider. Sorry about that.
we had them in the
A
VASA,
lot of testimony on
and I'm not sure that we had looked at the languages recently, but we certainly heard about what their scoop was. And they testified to the piece, and very much in favor of it. The DMV was in favor of it.
There were some of these ATVs getting by because nobody's actually measuring them or not all the time. So.
Is there, we're not deciding your vote today, but is there anybody looking to hear any additional on this piece from anywhere else?
You know, I'm kind of confused with this. Sorry.
Yeah,
That's
what we're,
after 72 inches, it says with 2-wheel ATVs having permanent full-time power to both wheels. 2-wheel ATVs, what's a 2-wheel ATV? Well, they have 4?
Most of them.
Most of them do. I remember the three-wheelers that used to tip over from when I was a kid.
Do they mean two-wheel drive?
Well,
Why would they?
that's a good question. So each of these should be read as a different piece of the definition. So you start with it's a non-highway recreational vehicle that's not a snowmobile, having not less than 2 low-pressure tires, 10 PSI or less. So it has to have at least 2 tires, 2 wheels, could have 4, could have 6, could have 8. Not wider than right now 5'4". This would make it 6 foot. And then it says here, the final piece is 2-wheeled ATVs have to have permanent full-time power to both wheels. I don't know what a 2-wheel ATV looks like, but I also don't know what the intent was and what the vehicles that were available at this, when this was drafted were.
You have the Segway or something?
Oh.
Remember the Segway?
Or one of those huge fat tire two-wheel, but it's still like a little motorcycle, isn't it? You know, they have those big fat tire looking, the ones they drive on the snow and whatnot.
Yeah, I mean, that's the thing. You've got the motorcycle as the one behind the other, I assume is going to fall under the definition of motorcycle. I don't know if there was some sort of, two-wheel side-by-side wheels ATV, or maybe 2 wheels with a skid or a ski.
Oh, yeah. Wow.
But I have to imagine there's some sort of specialty ATV that was available when they drafted this, where they wanted to encompass that and just require that it has to have power to both wheels in order to qualify.
A 2-wheeled ATV is essentially an off-road motorcycle, often referred to as an off-highway motorcycle.
Okay, so it's got a front drive as well as rear drive motorcycle.
Which would be a Rokon. This company called Rokon, it's the only one I know of that has power to front and back.
I know they've got e-bikes now that are coming out with the front and back power.
That's what they're trying to, it might be.
So, but I think that was, those post-date the statute though. They're still pretty new, but yeah, okay. So, but either way, it requires permanent full-time power, so that would differentiate it from a regular motorcycle, which is just rear wheel power.
Off-road, 2-wheeled ATV is a motor vehicle, 2 tires, specifically designed for off-road use.
Never seen one.
I don't get what they're doing there.
Yeah.
There.
Yeah, I would flag that at some point, this could probably use more of a cleanup. Just because the fact that we're having this conversation or we're trying to figure out what's what is a good sign that the language is confusing. I don't know that this bill this late in the session is the vehicle, but it might be worth, digging back in at some point. And it's something that the DMV General Counsel and I might come to you with a proposal for technical corrections next year to just clean up some of these sections.
This specifically is just to allow wider ATVs. Which,
Yeah, so all this is doing functionally is saying that instead of 5'4" wide, you can go 6 foot wide now. And so that's to accommodate changing products, which are supposed to be more stable than the prior versions of ATVs. So, all right. That's okay. Okay. So I had the purchase and use tax study committee, which is the last one, is still open with DMV requesting that it be removed. Sorry.
Section 43.
43.
They testified today that they are opposed to this section.
Yeah.
And that their main priority is related to the DMV phase 2 or 3, whichever one it is, rollout in November, and that's where all their resources are going, et cetera. But that's what I heard this morning, but that doesn't mean we're ready to make that decision. It's a question whether we want to hear more about it. You had a question or
Well,
comment?
I was just going to talk about the exploration of the onboard diagnostics issue. And if they were, but if they're not gonna do it, then it's fine. I mean, we were just gonna discuss, I guess, sort of eliminating that, but
Candace,
I thought that needed to have a lot more
Candace.
Chloe,
discussion.
Is there
Or cup.
Oh,
T, is it kind of?
no, no, the one behind the laptop.
I don't know if there's anything.
It was tipping.
Okay.
Oh. Thank you. But it's like, anyway, but if it's moot, then,
I'm not saying I didn't make
yeah.
a decision saying we're taking it out, but that's certainly what their testimony was. Did you want to add something about? what
No,
was
I
going-
just thought
Go ahead.
that it, I know that there was another bill that somebody brought in about getting rid of that requirement, but and we've just had a lot of discussion about that over the years about, first of all, that we needed to do it because of the Vermont being a nose in transport zone. And that taking that away would affect that. I just would like to have a discussion about it, if it's gonna go up.
Yes, go ahead.
When it comes to the inspection part, I guess I want to hear the whole part about forcing some level of review of the whole thing on a regular, basis about what should or shouldn't be included and whatnot on reviews, but that's maybe not exactly the same angle, because the light is what we heard about emissions.
Yeah, and what I'm saying, I mean, there was somebody who used to work at A&R, his father was a mechanic, and he just said, if every time that light is on, it does mean something. It's not just, I mean, it used to be the thing, why does this light keep going up? Various reasons, but I don't know whether it's worth getting into this whole thing right now. It's just something I'm concerned about if people are thinking about, oh, well, it's not safety related, simply get rid of it, that's all.
So there,
It's not as simple as just getting rid of it.
Well, because it impacts air quality and it impacts our requirement to meet our categories in ozone transport zone.
It does, that is what, and we are definitely hearing more testimony because I'm sorry.
I'm sorry, I just can't stop.
The Lieutenant Governor wants to be heard on this piece, and they put this in here somewhat related to his piece or not? Or was it a different issue?
this came up related to an issue of the testimony that I heard, and I may not have heard everything, related to an issue where a car was purchased, there was a warning light on, and the cost to get the warning light off was quite significant. And the individual couldn't pass inspection to get their car on the road without paying. It was over $1,000. I don't remember the exact details. I do remember that there was a significant cost. And it tied back in with the purchase and use. I believe this was like they bought the car, they were going to get it inspected, and they had to pay this purchase and use for the clean trade value of the car when there was an issue that immediately cost them thousands of dollars out the door, but they still had to pay the clean trade value. It's worth noting that it might make sense to review the inspection manual on indicator lights. This is something that in the Senate, right before this bill passed out, the issue came up about, are there any inspection warning lights that come on for anything that's not emissions or a safety issue? The deadline to get the bill out the door so it could go to the floor was moments away. And so they said, well, the House can look at that. So, but it's worth noting that it currently provides in the inspection manual to reject a vehicle if the ABS failure warning light is on, or if the light does not illuminate, meaning it's gone out, or for some other reason the circuits are not functioning. The brake system failure warning light is illuminated after the engine is started and the parking brake is released. Brake and or anti-lock brake warning lights remain on. The airbag indicator fails to light or continuously flashes or stays on. The speedometer does not illuminate. There's a couple of other ones. Advise if the tire pressure monitor system warning light is activated and may be malfunctioning. You must recommend a repair, but it's not a fail. And then there are a couple of other indicator lights that show up. There's a bunch of advice if the advanced driver assistance systems are not operating or if their warning lights come on during the road test portion. There's a seatbelt indicator rejection if that lamp continues to flash or remains illuminated when the seatbelt is fastened. So they do come up, and then there's the indicator light for the malfunction in the exhaust system comes up, which isn't technically a safety issue, that's an environmental issue. And so that may be something that you also want to look at there. And then without going through the rest, you get the sense of what's in there. But there's 30 instances of indicator that appear in the inspection manual. And some of them are advised, some of them are reject, and it might make sense to just give them a rundown of the ones that are rejection, the ones that are in advise, and then see if there's anything that's a non-safety issue that's not tied into the emissions compliance requirements that could raise this issue, because it may be something you want to just take out or modify.
Representative Pouch is
Yeah.
next, and then
I'm open for doing this, and I would think that the DMV could advise, they're the ones who came up with the list, they could advise whether they think they need an update. But the emissions piece, I'm guessing is a federal regulation. So it's not the state that says you gotta put these lights in. So I think we would need to just look at that, make sure. Because there are many states that don't have safety inspections, but have emissions inspections because of that. They're in areas that it's required by the federal government, I believe. So we would just need to check that.
okay. Representative Burke.
Yeah, we had lots of discussions about this. And there were issues, there were certain waivers that you could get and waivers, but it's trying to balance the fact that it can be very expensive for somebody to fix that. But at the same time, we needed to comply with the EPA regulations. And there was also something that we were going to investigate. There was like a hardship. I don't remember, we put in some things to help people not have to pay so much. I can't remember. And the person who really knew a lot about this and testified a lot is Megan O'Toole, who's now gone to another. She's not with anymore anymore, but she knew a ton about this, and we have lots of discussions and trying to work out the balances between how can we help people. And I think cars that are over 16 years old or something do not have to comply. I
Or
can't,
if you spend so much money.
I can't remember. I don't
Right.
remember all the discussion.
The biggest thing is they had a year, they didn't have to pay it all from the end of the year.
Yeah, but also older cars don't have to.
Correct.
Have to comply. Yeah, so anyway.
I just want to mention that I know the tailpipe standards got detuned there by Lee Zeldin at the EPA. He hasn't changed California. The California standards, but I know they did something to the tailpipe standards, so. I think that's forever changing right now.
I don't know.
I just read today where he was going to do some more things too coming up. I didn't have time to read it.
So it might make sense on that if you have questions about the emission standards and where things stand to have in, so that those are set by ANR, not DMV. And then A&R works with DMV to incorporate the requirements into the inspection manual. But you may also want to have someone from the air quality program over there come in and talk about what their requirements are. And our in-house expert on that is Ellen Tchaikovsky in our office. So that all falls under the air quality program, and then it just sweeps in vehicles. But I don't know quite how the interplay works between the EPA requirements and then with the California waiver. And with Vermont following the California waiver, if we follow the California emission standards or the EPA, or there's an interplay where those trade off, she would be able to better answer that. And definitely the folks from A&R could give you a rundown of what's going on at the federal level, because I think they are tracking that day to day, because it's changing what they have to do. Or impacting it
Well, I
potentially.
imagine we're probably paying attention to California standard at this point.
Right. Yeah, I mean, we follow the California waiver, but I don't know how far that extends to what goes on at your inspection.
Yeah.
So. That is the end of the draft. Just effective dates beyond that.
Which do have some piece related to some, the IDs might want to be sooner or whatever, a passage or the, then there was the one about
So
November or whatever that.
Yep. So the IDs are effective right now on July 1, 2025. You could make those sections effective on passage.
That's what.
If you wanted to change the allow for the folks to apply for the extension right away or early renewal, however we're phrasing that. Trying to think if there are other sections in here. I think most of the other sections are probably fine with a July 1 effective date, but if I'm overlooking something,
Okay.
then
Well,
just let me know.
We're
And
gonna get to it over the next
yeah,
bit that we have, so.
effective dates are easy. That's the easiest drafting in the bill. So if you want to change those, I'm happy. Everything else, you're stuck with it. You either got to take it out or keep it. Just kidding.
All right, so for my notes anyway, all the way back at the beginning, section 5. DCF, it's also been found on section 5 and section 9. Section 6, whether we do or don't want to get somebody like Vermont Least City and Towns to comment on that, but that sort of seems pretty solid.
Section what?
5 and 6.
5 and 6, I'm sorry, section 5 is DCF, but also section 9 is DCF.
Okay.
So 5 and 9 have some, they can comment on both at the same time. Section 6, we had kind of made a note that we might want to have a follow-up with that. That seems a pretty generous, allowing a discount. Number 8 was a pretty substantial money piece, so we at least, whether there's a testimony or more committee discussion on that one.
Yeah, for questions about SSI and SSDI and other potential waivers, Dale would probably be the first place to ask about whether there are additional benefits set out elsewhere in statute if you're trying to get context outside of the motor vehicle realm. So.
We were mentioning 9, section 11 is one of the multi-sections we're gonna run by the judiciary chair. 15, 16, and 17, we were going to hear a little bit more about the drive for why the renewal and what it's for. And then 19 or 18 was that new work. More discussion on that or understanding what the DMV was gonna do there.
Looking at the operator's license or.
18 was just the outreach,
The outreach portion of that followed up then from the previous page. That's probably where we're
right?
at.
And yes, the clarification on operator's license, operator's privilege card.
And 22 is in the multiple sections related to anything to do with the value of a used car and a purchase of use tax that's pro to it. At the very least, we know that that's all sections the Lieutenant Governor is gonna speak to, and there's multiple sections besides 22. Number 23, we're looking at AARP.
Did you want to hear more testimony on that second bullet?
In 22, yes, that's gonna be tied in the same as hearing from on section 36 and 43. For the Lieutenant Governor to speak to, and then perhaps some others as well. 23 was Ways and Means or AG or AR, finding something about who we're limiting with 1 year. 25, fuel dealers is where we're gonna start, at least on the refund limitation for a year. Then just running 31, 32, 30, 31, 32. All of those sections, at least for the judiciary piece, but they're not anything for us to do, just for the judiciary. I am gonna let Chair James know about section 33. In Ways and Means. We're not gonna do anything different here in the committee. 36, we already mentioned, Lieutenant Governor. And all of the section of tinted windows, figuring out what we're gonna hear or do about tinted windows. That's 38, 39, 40, and 41. 42 is the ATV, and other than finding out what a two-wheel ATV is, I think we're pretty well set on that one, unless I hear differently from anybody else. 43, we already mentioned Lieutenant Governor. And air quality ANR potentially, or looking at how we might handle inspections differently, or require an overall review every X number of years, something. There will be more committee discussion and testimony on 43. So if you're wondering what we're gonna do the rest of this week and next week, that's what we're gonna do. Those are the sections. Did I miss anything? Anybody have anything they want to add? Okay, we're going to, Representative Pouch is going to bring, was looking at that. Now we're gonna reschedule with Damian tomorrow's piece with the related to the safety zone pilot project. That testimony's been postponed. One of them is not available, and the agency is still looking for a solution. Representative Pouch is still working that. So what was on the schedule for tomorrow, your agenda is no longer valid. That's been bumped. So Representative Pouch and hopefully our alleged counsel will be here to present their piece. We're gonna look to get the Lieutenant Governor in earlier. I'm hoping that we can reach out to the fuelers dealers. They always seem to be able to be available. Perhaps they can speak on their section 25. They're in the building most of the time. If they can speak on section 25. And then we could reach out, Vermont Leagues of Cities and Town, they're in the building every day, section 25 and section 6. So we will fill up. There's a lot of to be determined on the agenda for tomorrow, but our goal is to work through those sections as soon as possible and get what's at least written in the DMV up.
Damien, at 10:45 tomorrow,
Mhm.
are you available?
I have a conflict on, well, maybe not. So my schedule, shows me only being on the schedule for an hour downstairs. It is for those of you who are familiar with it, it's S4, the bill relating to legal trails and municipalities' jurisdiction over them. So if you're not familiar with it, that testimony has been, or that bill has been extremely controversial. So
Yeah.
What was?
it's S4 relating to legal trails and municipalities' authority. Really to maintain them. Which is the subject of ongoing litigation between a municipality and a property owner. And because of that, that's sort of it raised all sorts of issues for the committee and made the bill particularly intensive with a lot of interested parties. So right now, my calendar says 9:30 to 10:30, but their agenda says 9:30 to noon. So I'm a little wary that I just didn't get fully booked for the amount of time they're expecting to have me for.
Went past that, so
Yeah.
it goes
It goes.
10:45 and then-
11:30.
And then you also, the state police is getting bumped, so you could
Oh,
do,
yeah, or we could do. it
anywhere
after.
before noon is open. And then
Oh,
after
right,
the floor
after the
too.
floor.
You got plenty of options.
And I
I can
can
lock you down for that.
definitely do after the floor tomorrow. And then if I get free in the morning, I'll just come up.
So after the floor tomorrow, I guess, is be safe or whatever, but, or either way.
Yeah,
She's working on a few of the other ones that we've sent that way and the adjustments that we're been talking about. Okay,
you're good.
thank you. Plenty there. That legal trails S4, if it ends up in here. That is quite something. The basic gist is that at some point or another, at least the really basic, there was a big move by the legislature to allow class 4 roads to turn into legal trails, they called them. And they maintain, the state or municipality would maintain that right of way in perpetuity. And now private landowners are saying, oh, but it's been mine for, or I've been using it for however long, it really should revert to me. And the municipalities are saying, no, we should be able to, it's our right of way forever. And a lot of trails to get places to and from are very much tied up into this. And because it says trails, I guess is how our nexus is.
No, it's in your town highway law.
It's down Highway
19.
municipality, so that will end up getting here.
Yeah, so it's worth noting, these are different than like the trail that you might think of. The long trail is not included here. The trails that your town has and parks and stuff, not the same thing, town forest.
Or road.
They are class 4 roadways that were discontinued as a town highway, but designated as a trail, which means that when the municipalities did that, they retained the 49.5 foot wide right of way for the public. And the big issue here is that some of these trails have been designated and they've just kind of overgrown. Others are well maintained. But in that particular case, the landowner is arguing that the town no longer has the right to maintain the trail. And the landowner has the right to maintain that trail. So the good news is, even if they move S4, they would just go to House Rules and then not come here till January. The bad news is there's a piece of S4 in the T-bill. So if it doesn't get removed before it votes out of the Senate, you will have to deal with it.
Okay.
Is the issue about?
So if you guys want, I'm sorry, if you want to keep.
I'll talk to you when we're off.
Whether to adjourn it or not, and conversation going, I've got to leave, so if you want to keep it open, if you're talking about S4, go right ahead, but I'll catch up with Tim and
I think
I'll
we're
be back
good.
if you're still here.
I'll catch the chair really quick and then I'll talk to you.
So I guess we.